This section will provide you with information on key concepts of GDPR as well as data protection principles. Personal data protection is an important component in the digital information age. The number of organizations that have access to and process personal data has drastically increased in the last years. As such, the protection of personal data has become a serious concern that requires commitment from organizations. As individuals interact with systems, products, and services that organizations offer, it has become increasingly difficult for them to understand the impacts or deal with the potential consequences of these interactions. Recently, governments and independent organizations have taken measures and are launching initiatives to tackle data protection issues and concerns. From a non-governmental perspective, ISO published many standards such as 29100, a privacy framework, 27701, a privacy information management system, and it added them to the successful family of 27000 standards. Personal data categories are spread over 7 domains. Special categories of personal data such as race, ethnic origin, health data. Data on biography such as date of birth, marital status, or data on appearance such as facial recognition, height, weight, or skin color. Data on education, job such as your working hours, salary, grades, assessments. Data on private life such as photos, videos, IP address, your phone log and phone calls, and data on health such as your sick leaves, doctor visits, and medical history. According to GDPR Article 5, the processing of personal data is allowed only under the conditions of the following data protection principles. So we have 6 main data protection principles: lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity, and confidentiality. Let us take those one by one. Processed data, which is lawful, fairness, and transparent, it means that this data is in a transparent manner in relation to the data subject. For example, if you're visiting a website and you're downloading a PDF, after providing your email address, you should give them consent to use your email address to target you for marketing campaigns, for example. Purpose limitation is when data collected for specified, explicit, and legitimate purpose and is not further processed in any other manner. For example, sometimes supermarkets collect your phone number and email address to target you in special campaigns. If these supermarkets share this information with any third party, this is in total violation of the purpose limitation. Data minimization is when adequate, relevant, and limited data to what is necessary in relation to the purpose for which they are processed. So it means that you're collecting data only in relevant to the purpose. For example, if you are helping a company find correct candidates for a certain job, and these candidates are filling the job forms, it is not necessary to collect information, for example, related to the health of the candidates, because this is totally irrelevant to the current situation. So this is in violation to the data minimization principles. The fourth principle is accuracy. Accurate and up-to-date data should be kept in the systems. If you have, for example, contacts or clients that have moved from one country to another or has changed the address, but you are still maintaining the previous address as the current one, this is in total violation of the accuracy principle. You should have this address as a history record, and the new address or the country of residency should be updated. The fifth data protection principle is storage limitation. Storage limitation means that you are storing the data as long as it is necessary for the purpose for which it was collected. For example, if you are collecting information for the sake of launching a product and the product has been launched, it is against the storage limitation to keep this data after launching the product. Last but not least is the integrity and confidentiality principles. It means that data should be processed in a manner to ensure appropriate security of the personal data. For example, if you are giving your employees laptops to work remotely, the laptop's hard disk and the data on the hard disk should be encrypted to protect against any data breaches or possible thefts. Now let's talk about principle of accountability, which is key here. The principle of accountability requires that data controllers or processors are responsible for and able to demonstrate compliance with the GDPR requirements. So how can they do so? The range of processes to be used by organizations to demonstrate such compliance will vary depending on the nature, scope, context, and the purpose of data processing. However, there are some guidelines. For example, you can implement appropriate set of technical and organizational measures, such as internal data protection policies and procedures, staff training, internal audits, and periodical reviews of your internal policies and practices. You can as well maintain a relevant set of documentation, like the name and the details of those individuals who are involved in data processing activities, the purpose of the data processing, description of the categories of individuals. As we've discussed before, we have around 6 categories of data, the categories of the recipients of personal data, detailed description of transfers to third party, and the retention schedules. Certifications such as ISO 27701, which is the privacy, is the closest an organization can get to prove that it has set up processes, and organizations can be certified against this standard. If the processing includes special categories, as we've seen before, or criminal convictions and offense data, an additional condition for processing this type of data needs to be identified. So what are the additional conditions? Processing shall be lawful only if and to the extent that at least one of the following applies. The data subject has given consent to the processing of his or her personal data for one or more special purposes. Processing is necessary for the performance of a contract. Processing is necessary for compliance with a legal obligation. Processing is necessary in order to protect the vital interest of data subject or another person, a natural person. Processing is necessary for the performance of a task. Processing is necessary for the purpose of legitimate interest pursued by the controller or by a third party. Let us talk in more details about the legitimate interest. Legitimate interest is considered as a lawful basis for the processing of personal data. The best way to conduct a legitimate interest assessment to know whether you're allowed to process data is to be upfront and transparent about all your processing activities. There are 3 parts or elements used to analyze the basis of legitimate interest. They include identifying a legitimate interest, obviously, showing that the processing of the data subject personal data is necessary, and balancing the legitimate interest with the data subject's right and freedom. You need to conduct LIA or legal interest assessment before the processing of personal data. The legitimate interest may be appropriate when the processing of personal data is not required by law, but it is beneficial to the controller or the third party. There is no impact in the privacy of data subjects, and the data subject is unlikely to object to the processing of the personal data. A careful analysis should be conducted in order to determine whether a legitimate interest is best choice or a lawful basis for the specific processing of the data. Let's give an example here. An organization has noticed improper behavior from one of its employees. Regarding the decision on whether to dismiss that employee, an organization needs advice on employment law. As such, the organization should send the employee's personal data to its external legal advisor. Prior to this, the organization must perform an LIA or legitimate interest assessment to determine the lawful basis of the processing. Article 7 is very important because it discusses the consent of the data subject. So when processing is based on consent, the data subject must give the consent to the processing. This consent may be withdrawn at any time. It should be easy to withdraw a consent as to give the consent in the first place. So article number 8 specifies requirements in relation to offering information society service directly to a child. The processing of the personal data of a child shall be lawful where the child is at least 16 years old. Where the child is below the age of 16, such processing shall be lawful only if and to the extent that consent is given or authorized by the holder of parental responsibility over the child. For example, the consent age in Belgium is 13, in France it's 15, in Germany it's 16, Netherlands as well is 16, in Spain it's 14 years old, and it is 13 as well in Finland. The controller shall make reasonable efforts to verify in such cases that consent is given or authorized by the holder of parental responsibility over the child. GDPR Article 9, it's on the processing of special categories of personal data. Processing of personal data revealing racial or ethnic origin, political opinion, religious or philosophical beliefs shall be prohibited. Of course, there are some exceptions. The exceptions are when the data subject has given a consent, when the processing of personal data is necessary for employment and society security, when the processing of personal data is necessary to protect the vital interests of data subject, the processing of personal data is carried out by a non-profit organization and bodies in the course of their legitimate activities, when the processing of data manifestly made public by the data subject, when the processing of data is necessary for legal claims, when it's necessary for reasons of substantial public interest, when it's necessary for individual healthcare purpose, for public health issues, and when it's necessary for archiving purpose in the public interest. GDPR Article 10 discusses the personal data with regards to the criminal convictions. This data can be processed only under the control of an official authority, the government here, or if authorized by an EU member state. Article number 11, processing which does not require identification. So if the purposes for which a controller processes personal data do not or do no longer require the identification of a data subject by a controller, the controller shall not be obliged to maintain, acquire, or process additional information in order to identify the data subject for the sole purpose of complying with this regulation. Where in cases referred to in paragraph 1 of this article number 11, the controller is able to demonstrate that it is not in a position to identify the data subject, the controller shall inform the data subject accordingly, if possible. In such cases, articles 15 to 20 shall not apply except where the data subject, for the purpose of exercising his or her rights under those articles, provides additional information enabling his or her identification.